So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have a
you can
lease
go
with-
challenge it. With who?
With Whitlaw. Miss
Then
Whitlaw, who
you
is
need to
supposed-
go against Miss Whitlow.
This hearing takes a sharp turn when the defendant challenges the court's authority, then suddenly tries to change her position. What started as a dispute over $1 million property is about to become a tense courtroom battle over standing, contracts, and possession. Watch closely, because the judge's response makes it clear that courtroom strategy has consequences.
Claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. This is a $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. We would like to move.
The case begins with a property dispute that is already far more complicated than a normal eviction. The plaintiff says the home was purchased with a mortgage and later became tied to multiple bankruptcy filings. Now, another person claims the property as her residence, with several competing claims surrounding the same house. The judge has to determine exactly who has a legal connection to the case.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that
Here comes the first major clash. The defendant tries to limit her appearance by saying she does not consent to the court's jurisdiction, but the judge immediately focuses on a basic issue. She is not the named party in this case. Whatever agreement she says she has may be important somewhere else, but that does not automatically give her the right to control this proceeding.
So I don't know why, on those grounds, why I'm hearing from you.
okay.
And now the courtroom reaches its turning point. After realizing the jurisdiction argument is not working, the defendant attempts to withdraw what she just said, but the judge refuses to treat the hearing like a reset button. His reaction exposes a problem with changing legal positions in the middle of a proceeding. Once an argument has been made, simply taking it back does not erase what happened.
A raid, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the
This is where the pressure reaches its peak. The judge makes a decision on possession and gives the plaintiff the ability to proceed with an eviction after the specified period. But there is another major consequence. An appeal bond is set based on the property involved. Suddenly, the defendant is facing not only the loss of possession, but a substantial financial barrier if the decision is challenged.
$15,000 a month appeal bond she definitely can't afford. Judge Simpson didn't even flinch once the entire hearing. And that is what happens when you try to run a scheme on someone who has seen it all before. A few weeks later after this court hearing,
The final exchange makes the outcome even more striking. The defendant questions the amount of bond, but the judge explains that she does not have standing to challenge that particular order. The courtroom battle is effectively over. The plaintiff has received judgment for possession. A 10-day timeline is in place, and the appeal would require the specified monthly bond.
she actually failed to pay the monthly rent. So as this video has gone up, she is currently no longer in this $1 million home. But yeah, guys, let me know in the comments. Do you think she actually had a plan walking in here, or was she just making it up as she went?
This hearing shows why courtroom arguments have to be backed by a clear legal position, not simply repeated claims. The biggest lesson is that changing your argument mid-hearing does not automatically change the court's decision. What do you think? Was the defendant genuinely confused, or was she trying every argument she could? Let us know your opinion.